Hi. Today we're going to be discussing the abolishment of the death penalty and why it doesn't work. My name is Genesis Miramontes.
I'm Calvin Pham.
I'm Jamie Hernandez.
I'm Dallas Scott.
Before we start talking about the death penalty, let's actually look at its history within the United States. Now, what do we define as the death penalty? It is a practice whereby a properly constituted authority puts to death a convicted offender in punishment for a crime. Now, why was this even an option? Well, prisons didn't actually emerge until the late 1700s and early 1800s. So early forms of punishment in colonial America actually consisted of fines, short-term incarcerations in local jails, and public shamings. By necessity, capital punishment was criminal law's principal defense against repeat offenders and other criminals who threatened individual safety and the social order. So only a few crimes were actually punishable by death, though. And these crimes were murder, rape, adultery, sodomy, bestiality, and property crimes. Note how there was actually a stark difference from how England's Bloody Code, which labeled over 200 offenses as capital crimes during the mid-18th century. Now, important early reforms to note occurred during the mid to late 18th century in the form of jury nullification, in which jurors would actually refuse to return guilty verdicts in cases that would result in capital punishment. This was mostly in defiance to the overextension of the death penalty to crimes such as property crimes, which were deemed less grievous. In 1786, Pennsylvania actually did away with capital punishment for robbery, burglary, sodomy, and buggery, and even later defined first-degree murder and abolished the death penalty for all other offenses. By 1860, no northern state punished crimes other than murder and treason with the death penalty. Now, notice how I said northern states, because there were actually regional differences in how criminal law and the death penalty were applied. In southern states, there was actually a lot of racial injustice, as southern states relied on the death penalty to uphold landowners' property rights and selectively chose to sentence mostly blacks to death. In 1838, Tennessee, Alabama, and Louisiana, all southern states, actually allowed juries the discretion to sentence offenders either to death or imprisonment instead of automatically resulting in death. Now, this might sound like a good thing, but it was actually a form of social control, as it allowed all white juries to determine the fates based on race. Notice how rape was punishable by death almost exclusively in the South. And of the 771 recorded cases, 701 of those were black. Post-World War II, we actually see a decline in the support for the death penalty. And for the first and only time, opponents of the death penalty actually outnumbered supporters in a 1966 Gallup poll. By the end of the 1960s, 14 states had either entirely done away with the death penalty or had narrowly defined the parameters of it. An important decision in Furman v. Georgia, in which the 5 justices had concurred that the death sentence had been imposed in violation of the Eighth Amendment's cruel and unusual punishment clause. Thereafter, state legislature focused almost exclusively on murder as a capital crime. Another important decision coming in 1977, when the Supreme Court ruled that death is a disproportionate punishment for the crime of raping an adult in Coker v. Georgia. Today, capital punishment can only be imposed in response to aggravated murder or in very few exceptions, such as federal crimes.
It has long been argued whether or not physicians should participate in the death penalty executions due to the question of ethics and morality involved in the medical profession. Based on its history, the methods of execution for the death penalty were created by physicians who wanted quote-unquote humane methods used. In 1789, during the French Revolution, Dr. Guillotine, who himself opposed the death penalty, urged the French National Assembly to adopt equally swift and painless methods of execution for the commoner as for nobility, and proposed a decapitation machine. 2 of the main arguments used against the death penalty include the ends of medicine and professional autonomy. In terms of the ends of medicine argument, physicians should only be responsible for healing people instead of using medicine to execute individuals. In terms of the professional autonomy argument, physicians should not involve themselves in state or social agendas. The use of the death penalty has declined and is concentrated in few counties. In the Glossop v. Gross court case, Oklahoma executed Clayton Lockett with a 3-drug lethal injection, and it went very poorly. The execution was botched, with Lockett waking up after and staying alive for 40 minutes. The dissenting opinion of Justice Stephen Breyer highlights the fact that just 29 counties, fewer than 1% of counties in the country, accounted for approximately half of all death sentences imposed nationwide. nationwide. With each year, there is a decline in the number of people sentenced with capital punishment. In the mid-1990s, there were about 300 people sentenced compared to today, which is now about 30 people every year.
So the death penalty, what are the pros and cons? So some pros are that it vindicates social order, it provides retribution for the victims, and it deters crime. Some cons include that it is morally unjust and an abuse of power, and that the death penalty has actually not proven to deter crime, and it costs more financially. So an alternative to the death penalty is life without parole. Studies have found that life without parole is the more severe and effective form of punishment. It serves as a more functional tactic towards deterrence of crime, and life without parole is more cost efficient compared to the death penalty.
While the death penalty is considered constitutional this current day by definition through the Fifth Amendment, growing opposition towards it is mounting as the public questions its relation to human rights. The Fifth Amendment contains prohibitions, not powers, and there is no reason to suppose that it somehow nullifies other constitutional prohibitions. Most importantly, the ban on cruel and unusual punishment. Today, the death penalty seems firmly entrenched in the United States. About 3,300 prisoners are currently on death rows waiting out their appeals. But new challenges against the death penalty are rising. Many nations are urging the United States to sign treaties against capital punishment. By 1998, 63 countries have outright banned the death penalty, and more than 40 other nations have severely restricted capital punishment. The United States has long championed human rights, but the death penalty is and always has been an inhumane solution. It is an unreliable practice, as many times DNA evidence has cleared someone awaiting capital punishment. It is an arbitrary punishment, as it only satisfies the emotional appeal of taking an eye for victims, rather than having the offenders serve their time and a chance at rehabilitation if possible. The amount of time the death penalty recipient must wait for their justice to be administered almost defeats the purpose it is trying to serve. It should also be known that many states in the U.S. have already abolished the practice, so the whole country should follow suit. Scientists agree by an overwhelming majority that the death penalty has no deterrent effect. They felt the same way over 10 years ago, and nothing has changed since then. States without the death penalty continue to have significantly lower murder rates than those that have capital punishment. The Journal of Criminal Law and Criminology contains a study examining the opinions of leading criminology experts on the deterrence effects of the death penalty. The results reveal that most experts don't believe the death penalty or the carrying out of execution serve as deterrents to murder, nor do they believe that existing research supports the deterrence theory. The authors report that 88.2% of respondents do not think the death penalty deters murder, a level of consensus comparable to the agreements among scientists regarding global climate change. The study builds upon previous research published in 1996, in which opinions of 67 leading experts in the field of criminology were surveyed. The most recent study sent the same questions to a new group of experts, among whom were from the American Society of Criminology as well as criminology scholars. The majority of respondents also expressed the opinion that the death penalty states don't have lower homicide rates than states where capital punishment has been abolished. The author points to empirical evidence that backs this up. In 2007, murder rates in states that still had the death penalty exceeded those in states that had been abolished by no less than 42%. Overall, the authors concluded that there is no significant difference between the opinions of experts from the 1996 and the 2008 time periods, and a vast majority of the world's top criminologists believe that the empirical research has revealed that the deterrence hypothesis is a myth. Thank you for viewing our presentation on why the death penalty should be abolished in the United States.